Leader of the Opposition.
Mr Deputy President, I lead for the opposition, the Labor opposition in debate on the Surveillance Devices Amendment Statutory Review Bill, which is cognate with the Terrorism Police Powers Amendment Statutory Review Bill 2018 and the Road Transport Amendment National Facial Biometric Matching Capability Bill 2018. The opposition does not oppose these bills, but we do have some concerns about the last one, which I'll come to.
What are the three bills?
Again, I note that the bills could each have stood on their own, and having spent the last 8 years under-utilising and mismanaging the workflow in this chamber, the government is now in a flurry of activity, lumping together as cognate a range of bills that don't warrant that treatment. The objects of the Surveillance Devices Amendment Statutory Review Bill 28 include appointing a Surveillance Devices Commissioner and inserting an objects provision in the Surveillance Devices Act. Additionally, the bill aims to make consistent the information that is required to be in a warrant, the information that is required to be in the application for the warrant, and the information that is required to be provided to the Attorney-General about the application for the warrant. The bill also aims to require an applicant to include in the application known information adverse to the application and to require an applicant to identify persons who may be incidentally recorded by the surveillance device. And this is very important, Mr Deputy President, for reasons that I will shortly come to. The bill is presented as responding to the statutory review of the Surveillance Devices Act and the report of the Ombudsman on Operation Prospect. The review of the Surveillance Devices Act is dated October 2018 and was tabled on the day that notice was given of the bill. In July 2015, the Shadow Attorney issued a media release saying the statutory review was then 3 years overdue. Its tabling in 2018 makes it 6 years overdue. This rivals the delay in the review of the Defamation Act. The opposition has often said that the government's legislative agenda reminds us of watching grass grow. Its process for statutory review is perhaps even slower than that. Some of the recommendations from this statutory review have forced their way into the bill. Recommendation 3 about optical devices, for example, is in Schedule 1, Item 3. Recommendation 2 seems to be dealt with in Schedule 2 of the bill. Not all of the recommendations of the delayed review have in fact been implemented in the bill. The other report relating to this bill and surveillance devices is the report of the Ombudsman on Operation Prospect. The matters that provoked that inquiry and report have been notorious for many years and have attracted considerable attention, including, well, I think 2 inquiries of this House, on both of which I sat upon, as well as the enormous Ombudsman's inquiry itself. All of that activity, of course, dwarfed the original police operation that was the subject of those inquiries. As a member of the Parliamentary Oversight Committee on the Office of the Ombudsman, the Police Integrity Commission and subsequently the Law Enforcement Conduct Commission, these are matters that have been considerable interest to myself as well as the Shadow Attorney. We remain outraged that a former Police Commissioner indicated that a 100-name warrant was necessary because of a police function which apparently did not in fact occur. The circumstances of that remain, at least to me, shrouded in mystery. The Ombudsman's report recommended the establishment of a public interest monitor similar to the Queensland and Victorian models for applications for surveillance devices and telephone intercept warrants. The Operation Prospect process revealed long-term and systemic problems with the issuing of warrants for listening devices. The Ombudsman's recommendation was to establish a public interest monitor in New South Wales. The parliamentary inquiry, I think, made a similar recommendation for, I think it was an Office of Independent Counsel, to act as contradictor on warrant applications. Of course, this proposal doesn't approach the contours of that recommendation by the parliamentary inquiry, but nevertheless this is an improvement on the status quo. Given that many more warrants are granted in New South Wales than in any other state, it is, in the Ombudsman's words, imperative that New South Wales has an effective regime in place for checking that adequate safeguards are in place. The safeguard of the Attorney-General's role has been in place for some time and in the Ombudsman's assessment has been ineffective. Merely improving that in a minor way was not adequate. As the Ombudsman said, and I quote, "Without systemic reforms, the weaknesses evident in New South Wales' current safeguards are likely to persist," unquote. The focus of the Ombudsman was on fixing up the front end of the warrant process. The government's response to recommendations 25 to 30 in Volume 5 of the Ombudsman's report is to create a position known as the Surveillance Devices Commissioner. This is a public service position that requires a legal qualification. New Section 51(b) permits the Attorney-General to delegate functions under Parts 3 and 5 of the Principal Act to a number of positions, including the Surveillance Devices Commissioner. This delegation power seems to be the origin of the Commissioner's powers. In his second reading speech, the Attorney-General specified what the Commissioner will do. The Commissioner will receive advance notice of applications for warrants with all the information that will be given to the Judicial Officer, assess whether the application is procedurally compliant, work with agencies to remedy inefficiencies before they are lodged, have the right to be heard by the Judicial Officer in relation to issuing a warrant, and receive reports about the use of the device. The Commissioner will prepare an annual report to be contained in the Department's annual report, setting out the number of applications made, withdrawn and refused, and the number of applications in which the Commissioner was heard. I pause here, Mr Deputy President, to indicate that placing these heavy responsibilities upon a public servant, I think, is a heavy burden to place on any person, but particularly a person who's not an independent statutory officer or independent of executive government. I hope in recruiting to the role that the government is realistic in the level of skills, qualifications that will truly be required for the proper and effective discharge of the role. Much of what the Surveillance Devices Commissioner is to do is similar to the recommendations of the Ombudsman and, of course, has an echo of the recommendations made by one of the parliamentary inquiries upon which I sat. There are, however, some significant variations, and we asked the government to explain in reply why the recommendations have been departed from. The bill does not extend the role of the Commissioner to deal with telephone intercept warrants, for example, as was recommended by the Ombudsman and I think the parliamentary inquiry. There does not seem to be an explicit acknowledgement of the entitlement of the Commissioner to ask questions before the Judicial Officer of any person giving information in relation to the operation. The reporting provisions in the bill are not as wide as those recommended by the Ombudsman. In particular, the Commissioner's reports would seem to be merely numerical, with recommendation 30 of the Ombudsman also extended to reporting information about the hearings where there was intervention to raise issues and to question applicant witnesses. The other issue that should be explained to this Parliament deals with the role of the Attorney-General. The Ombudsman's proposals seem to envisage the Attorney retaining a role, with the Public Interest Monitor having a separate role. The bill before the House seems to replace the role of the Attorney with that of the Commissioner, which seems to sidestep recommendation 28. It would seem to us to be appropriate to have some explanation of that placed upon the record. The issue of the Commissioner is the most important in the bill, although there are other provisions that should be noted, many of which reflect the Ombudsman's recommendation. A new objects clause is provided with a reference to a privacy focus consistent with recommendation 34. Recommendation 17 is amended, specifying the information to be included in the warrant. An affidavit must support the application, and it should identify those who may be incidentally recorded by the device. Of course, that was one of the notorious aspects of Operation Prospect and was subject to a recommendation by the Ombudsman and I think the parliamentary inquiry. The affidavit will have to include any information known to the applicant that is adverse to the application. Dealing now with the second of the cognate bills, the Terrorism Police Powers Amendment Statutory Review Bill 2018, the object is to give effect to the recommendations of a statutory review and involves amendments to the Terrorism Police Powers Act. The review was tabled on 7 June this year. It followed from a report of a review by the Ombudsman tabled in June 2017. The statutory review followed pursuant to Section 36 of the Principal Act. This is the sixth statutory review of the Act. The review covers the period from 2015 to 2018, during which time it should be noted that a number of amendments were made to the principal legislation. The review confirmed that Part 2 triple capital A powers and Part 2 capital A powers have never been used, and Part 2 capital A powers have not been used since 2014. The statutory review states, and I quote, "These powers, while rarely if ever invoked, provide the New South Wales Police Force appropriate tools to remain agile in meeting the terrorism threat. The Act provides the New South Wales Police Force necessary powers to intervene when the risk of terrorism begins to crystallise or where a terrorist act has occurred," unquote. For a range of different reasons, the rare use of these powers is a positive thing. One provision in the bill is Schedule 1, Item 23, which continues the Part 2 capital A scheme for 3 years. That is, the sunsetting will be deferred for 3 more years. The Ombudsman's report, to which I referred earlier, recommended that Part 2 capital A be allowed to lapse on 16 December 2018. It deals especially with preventative detention orders and prohibited contact orders. The then acting Ombudsman, Professor McMillan, in the foreword to his report, argued that Part 2 capital A powers, introduced in 2016, effectively made the Part 2 capital A powers redundant. Accordingly, Part 2 capital A should be allowed to lapse. That being the case, whether they lapse is perhaps not of great importance. The fact that they are not utilised in one sense may be a case for their continuation. One is hardly able to argue that they're being overused or used inappropriately if they're not being used at all. The opposition supports the bill as it is currently drafted. Schedule 1, Item 1 notes that the safeguards of Part 15 of the Law Enforcement Powers and Responsibilities Act apply to Part 2, Division 3 of the Principal Act in accordance with Recommendation 2 of the Statutory Review. Section 23 is amended so that the current 2-stage warning required to be given by police to a person concerning Part 2 powers is reduced to a single warning. Annual reporting is improved in accordance with the Recommendations 3 and 4 to improve the gathering of statistics. Schedule 1, Item 11 enables the Supreme Court to order that legal aid be provided to a terrorism suspect concerning proceedings related to the person's investigative detention. Proposed new Section 25 M requires suspects under investigative detention to be treated with humanity and respect for human dignity and not be subjected to cruel, inhumane and degrading treatment. Proposed new Section 25 M requires police to inform a terrorism suspect in investigative detention of the right to contact a lawyer and the Law Enforcement Conduct Commission, or LEC. The Act is also amended to allow police to take photographs or video recordings of a detainee to document an illness or an injury. This seems to be necessary because the police believe the current ban on obtaining identification material from a detainee extends to cover that situation. This proposal was made by the police to the review. The Act is also amended to require the police to advise a detainee that contact with the detainee and others will be monitored. The provisions relating to personal searches under the Law Enforcement Powers and Responsibility Act are applied to searches under the Principal Act. That was also a recommendation of the Statutory Review. The bill also increases the maximum limit to 4 hours from 2 hours for contact between a person under 18 or with impaired intellectual functioning with a parent and other person. Schedule 1, Item 18 requires police to offer further assistance and information to such detainees. There are also changes to the provision relating to the supply of information from the police to the LEC, which has of course replaced the Ombudsman in overseeing this regime. The Ombudsman in a previous review had reported that his oversight functions were hampered by his ability to access police information. This was caused by Commonwealth secrecy provisions and claims of public interest immunity by the police. The Ombudsman had called for the Principal Act to be amended to make it consistent with the Ombudsman Act and the Law Enforcement Conduct Commission Act that prevented public interest immunity claims in response to a requirement to provide information. The Statutory Review noted that it was concerning that the Ombudsman could not form a comprehensive and informed view of the operation of the Act without access to key documents. On pages 57 to 58 it said, and I quote, "Part 2 A powers are extraordinary and depart from long-established principles on detention. New South Wales Parliament recognised this when the legislation was enacted by establishing a robust scrutiny function. The New South Wales Police Force and the Law Enforcement Conduct Commission should work to address the issues identified by the Ombudsman," unquote. The end result is Schedules 1, item 22 and 1 item 25, which require the police to provide the information to the LEC subject to conditions to prevent sensitive information being accessed or made public. There is also a limited capacity for redaction or withholding information. This is not quite what the Ombudsman requested in previous reports. The opposition's view is not to seek to amend the provisions at this stage, but to see how they work and to address any changes needed subsequently. If the LEC advises at a later point that this does not work adequately, we will certainly reconsider our position. At the moment, we do not oppose the bill, and what is proposed in the bill is definitely an improvement on the current situation. The third and final cognate bill is the Road Transport Amendment National Facial Biometric Matching Capability Bill. The bill's object is to amend the Road Transport Act. The amendments aim to authorise roads and maritime services and certain other New South Wales government agencies to release photographs and associated information to the National Facial Biometric Matching Capability, to collect such material from that capability and to keep and use those photographs or information for any lawful purpose in connection with the exercise of the agency's functions. This capability is administered by the Commonwealth and stems from an intergovernmental agreement on identity matching services entered into by the Commonwealth, the states and territories in October 2017. The challenge in this era of big data is to get the balance right between the availability of information for useful purposes and, of course, the protection of privacy. Over the last 8 years, this government, we do not think, has got the balance right. As a consequence, the opposition has introduced several private members' bills during that period to try and do so. All of those proposed measures have been rejected by this government. Most obviously, this bill should be accompanied by a regime of mandatory reporting of serious breaches of privacy by state agencies. Such a regime is, of course, good enough for the federal government, but apparently not the current state government. We'll have to await the election of a Labor government in March 2019 to see this remedied. As I said, Labor does not oppose the bills, but we are cautious about the provisions in this bill particularly and propose to look closely at how they are implemented and what in fact happens as a result of their adoption. It's worth mentioning that in one of the innovations we are trialling in this place this year, this bill was referred to the Standing Committee on Law and Justice, and of course that committee of this House has reported on 12 November on this bill, and it's worth honourable members having a little look at that and to be conscious of and sensible of the concerns that stakeholders have, which are reflected in the report. During the short inquiry, the committee considered a number of concerns raised by stakeholders regarding the bill and, of course, the Commonwealth's Identity Matching Services Bill. And this is because the Commonwealth's legislation provides the overarching framework for the new biometric face matching services. The committee noted concerns by stakeholders, including whether there are appropriate privacy safeguards in both bills. As I've indicated, I don't think there is at a state level. There was also concern that New South Wales Parliament is enacting its regime before the federal regime is in fact put in place. It does seem to be rather putting the cart before the horse. The New South Wales Council for Civil Liberties, Australian Lawyers for Human Rights and the Law Society of New South Wales have all raised concerns with the present legislation, including that it facilitates the ability to provide information to local government and non-government bodies and is inconsistent with the Intergovernmental Agreement on Identity Matching Services, which of course is the stated basis for the legislation. There's also concern that the legislation contains ineffective privacy safeguards and is seen by some as creating a virtual identity card and may facilitate profiling, which of course would be most unfortunate. Further, the Australian Lawyers for Human Rights have argued that the bill before the House should not be passed because it opens up citizens to additional and unwarranted government surveillance. And I quote from their submission to the committee, quote, "The federal bills exempt the federal government from normal operation of Australian privacy principles and allow individuals' personal and sensitive information, including biometric data, to be used for any purpose the Commonwealth may wish. The federal bills do not respect privacy but enable surveillance and exploitation. New South Wales residents should not be made part of these arrangements, unquote. Australian Lawyers for Human Rights were also concerned that under both the state and Commonwealth bills, data is able to be obtained for one purpose but used for other purposes. And the Law Society, not a noted left-wing outfit, was also concerned about the scope and reach of the capability and the associated risks of unnecessary encroachment upon the privacy of citizens. So the absence from the legislation of a comprehensive data management or privacy code, as it were, is a concern. A number of inquiry participants noted their unease that the incidental collection of certain biometric data could lead to the capability being used for racial profiling, which I think is a legitimate concern and should be addressed by the government. Stakeholders were, of course, united in the view that the facial matching capability for the purposes of law enforcement, such as in the event of a terrorist attack or a siege situation, is a sensible and important measure, and ultimately it's for those reasons, of those considerations, that the opposition will not be opposing the legislation, but as I said, we are concerned about some of the matters that have been raised. The committee recommended that the government should use the opportunity of the parliamentary debate on this bill to address the concerns raised by stakeholders. That has not yet happened. We earnestly hope that the government will do so in reply before the bill passes this place. In particular, the committee, and this is at page 16 of the committee's report, recommends that the government during the debate on the bill should address the reasons why the road transport bill is being considered before the Commonwealth legislation passes, should address whether specific privacy safeguards should address why they're not included in the road transport bill, and also should explain whether New South Wales will allow its agencies to enter into participation agreements with local government and also with non-government bodies, because of course it is that possibility that raises serious concerns about how the data being collected will ultimately be applied. I think reasonable people will concede that the collection and use of this data for law enforcement and anti-terrorism measures is fine, but the danger of it being misused, leaked or used for other purposes is not. Government should only be collecting the data on its citizens for stated purposes, purposes directed to public safety and the like. So with those comments, we don't oppose the bills, but we are concerned about the third of the cognate bills and hope that the government addresses those matters before we vote.
Mr Deputy President.